Today we are going to discuss medical negligence. I hope this will helpful to the students of medicine and students of law and those who are preparing for the NEET PG. So, a study which was conducted by Health Grades in 2002 in America found that an average of 1,95,000 hospital deaths in America was because of medical negligence. And American Medical Association reports that 1,06,000 patients die per annum because of the medical negligence in America. So, what is medical negligence? Negligence means omission of something or doing something without proper care. That is what called negligence. So what is medical negligence? Medical negligence, it is the misconduct, a professional misconduct by the medical practitioners or doctors by not providing enough care and taking proper safeguards or measures that resulting in the breach of their duties leads to harming the patients. So that is we call medical negligence. When we talk about medical negligence, we should consider the important judgments by the courts of Kerala and Court of India, Supreme Court. So, one of the important case, Moni versus State of Kerala, in which court held that there may be one or more perfectly proper or reasonable standards of care, and the doctor or the medical practitioner conforms to one of these standards, then he is not negligent. This statement was given by the court in the case of medical negligence. The court says that if there is more than one options for a doctor, that means more than one reasonable standards of care, the court states that the doctor or the medical practitioner conforms either of these two, then we can say that he is not negligent. The doctor is always expected to be do the things perfectly, because the patients consider the doctor as a god. So the doctor is considering important persons in their life, and the patients trust in the process of healing or the treatment. They completely trust the process of healing. So the doctor or the medical practitioner has to take maximum care while doing their duty. So medical negligence in another case, one of the basic case or the famous case which give emphasis on medical negligence, Dr. Lakshman Balakrishna Joshi versus Dr. Trimbak Babu Godbole and others. In this case, the court held that the doctor or the medical practitioner will be negligent if he or she violate either of these three duties. So what are the three duties? These three duties which are stated by the court. The first one is the duty or obligation of care in finding out whether to undertake a unique case or not. That means it is the duty of the doctor to take maximum care while to undertake a specific case or not. And then another duty, the duty of care in deciding what therapy or what treatment that a patient is to receive in a certain case. So it is the duty of the doctor to decide what treatment will given to the patient. And the third duty, the duty of care in administering the treatment properly. So the third duty means the doctor should give maximum care in administering or performing the treatment properly. These are the three duties which are stated by the Honorable Supreme Court regarding this medical negligence. The doctor or the medical practitioner will be liable, or he is said to be negligent only if he or she violates either of these three duties. So we have that means the doctors, for controlling the performance of doctors, their conduct and character of the doctors regulated by a code of medical ethics regulation 2002. This act or this medical ethics code, which explains some important duties, the duties of doctor. The first one is obligation to seek. Obligation to seek means a physician or medical practitioner won't consistently be certain to deal with each individual who asks for his service, but he should continuously be competent to reply to the calls of the sick person or patient, and he will have to be mindful of the high character of his mission or obligation and the accountability he discharges in the direction of his professional responsibilities. In simple terms, a doctor or clinical practitioner advising a patient to seek provider of extra health practitioner is acceptable. However, in the case of an emergency, a health practitioner ought to deal with the sufferer. That means it is the obligation of a doctor or medical practitioner to reply the calls of the sick person or ill person. No healthcare or professional shall immediately refuse to offer to heal to a sufferer. That means the doctor, the medical practitioner has to reply the calls of the sick. He can or she can advise the patient to seek provider an extra health practitioner is acceptable. However, in the case of emergency, he has to deal with the sufferer. The second one is prognosis. Prognosis means the physician, the doctor, should never exaggerate or minimize the gravity of the patient's condition. That means the doctor should take maximum care while explaining the condition of the patient. He or she never exaggerate the condition, and he or she never. So it is the duty of the doctor to explain the real condition of the patient to the patient or patient's family members. The actual condition of the patient should be conveyed to the patient or the members of his family or those who are interested in the well-being of the patient. So the third one is patient's delicacy and secrecy. These are the three things that a doctor should have. So patients, we know that what is patient. So the physician or the doctor must have the patience and delicacy. And another thing is secrecy. Secrecy, which means the confidentiality about the details of the patient and his ailments need to be maintained by the physician. However, in few cases, the physician may reveal about these matters if he feels that his duty towards the society or any particular person is more important. For example, if there is a new form of hazardous or transmitting disease, then the confidentiality of the disease cannot be kept. Simply, it means that the doctor or the physical or the medical practitioner should keep the condition of the patient secret. He can reveal the condition of the patient only when he thinks it is necessary. That means the public, for the interest of public, like in the case of transmitting diseases. In such cases, he can reveal the condition of the patient for the interest of the public, general public. And in the case of investigation purposes of the police or investigation agencies, in such cases, the doctor or the medical practitioner can reveal the real condition for the purpose of such investigation purposes. Another thing is the patient must not be neglected. The doctor or the medical practitioner should not avoid any request from the part of patient. The doctor is free to choose whom he will treat or serve, but he should respond to any request or need for his assistance in the case of an emergency. After undertaking a case, the health care professional or health practitioner must not forget the sufferer and must no longer withdraw from the case without giving sufficient information to the sufferer and his or her family. Professionally or fully registered medical practitioner or doctor should not willfully commit any act of negligence that may deprive his patient or patients of the required standard of medical care. The last one is engagement for an obstetric case. Engagement for an obstetric case. When a doctor or medical practitioner who has been engaged to attend a obstetric case is absent or unavailable, in such cases, a doctor is sent for and delivery accomplished. That means, in some cases, the doctor he engaged in obstetric case, so he is not available for the patient. In that situation, another doctor is sent for, and the acting physician or the doctor is entitled to get his professional fees, but should secure the patient acceptance or consent to resign on the arrival of the physician engaged. These are the duties which explains in the Code of Medical Ethics 2002. Also, this code includes 3 acts of misconduct. The first one is abuse of professional position. The first one is abuse of a professional position. It means they should not attempt to do misconduct by using the position in their profession. We know this profession is a divine profession. The profession of doctor or medical practitioner is like a divine profession. So the patient consider the doctor or the medical profession as professional as a god. In such position he is engaged. So he never attempt to do misconduct by using the position, committing adultery or improper conduct, or maintaining improper association with the patient by using his professional position. This is the first one. And the second thing is not taking the consent of the patient. Not taking the consent of patient. It means performing a treatment without taking the consent or acceptance in writing form of the spouse, parent or guardian in the case of minor, or the patient himself as the case may be. and constitute misconduct. So taking the consent in the case of serious treatments, taking the consent is very necessary, and if he fails to do that, he's said to be he is negligent. He's said to be negligent. So it is very necessary to take the consent of the patient, or his from the patient, or from the members of his family, or those who are really interested in the well-being of the patient. Okay, another one is violation of regulations and laws. We know the medical professional must follow some rules and regulations, which explains in the Medical Council Professional Conduct and Ethics Regulation Act 2002. This act contains all the duties, rights of a medical professional, and the doctor or the health practitioner or medical professional must follow these rules. The violation of these rules will lead to criminal legal consequence. So these are the things should follow by the medical practitioner. Okay, thank you.